appeal part heard in the matter of Floreat Investment Management Limited and Churchill and others.
Yes, Mr. Elias.
My Lords, yesterday your Lordships requested one or two documents, and the respondent has indeed adduced one or two further documents they wish to produce. So I hope you have an additional bundle that the respondent has just produced.
Yes.
Just to let you know very briefly what's in it. At tab 1, you will see the Burgess-Hammond retainer letter, which the respondent wishes to produce. At tab 2, you will see the draft of the cancellation notice, and then at tab 3, the final version of the cancellation notice, which was something that I think was asked for. And just for your reference, that's dealt with in the judgment at paragraph 224 onwards. At tab 4 is the deed of release, dated 23rd of June 2017. That's in two counterparts. And that's dealt with in the judgment at paragraph 177 following, and then briefly at 325 and 326. At tab 5 is the assignment of the causes of action from the fund to FIML. And tab 6 is a replacement for the supplementary bundle, tab 11. I understand the incorrect document, or the document immediately following this passage of the Bloomberg chapter has been included in the bundle, and the claimant wishes to rely on this particular document. So that's why those are those documents following up from yesterday.
Thank you.
One other matter which was raised by your Lordships yesterday was the judge's findings in relation to the individual defendant's knowledge of the offering memorandum. And you may recall that we looked at, this is in relation to the, I referred your Lordships at the time to paragraph 57 of the judgment, where the judge said, I was satisfied at the trial that the individual defendants were at all material times familiar with the offering memorandum. I should also refer your Lordships to paragraphs 135 to 136 of the judgment.
Yes.
And you'll see that the judge makes findings that Mr. Diallo was aware of the term of the break fee clause, although of course there's no finding as to how he understood that clause. And similarly, that all three individual defendants were aware of the terms of the NAV assessment requirement. And similarly, that they ought to have known about the NAV assessment requirement and break clause. And at 6.9, that they had constructive knowledge of the NAV assessment requirement and break clause. You will see from the judgment that the judge finds that they knew of the existence of the clauses in some way, but he doesn't actually make any findings as to how they understood those clauses or how they understood the effect of those clauses, what the effect of those clauses should have been. The further reference is at paragraph 334. And there's a further relevant passage there where the judge says, I can accept the individual defendants had at the least constructive knowledge of the break fee clause and the NAV assessment requirement in the offering memorandum. That's another finding relating to knowledge, but says very little about what they actually knew or how they actually understood it. But that was a matter that was raised yesterday, so I draw those to your attention. And the final matter...
It's an odd finding, isn't it? If you've already found actual knowledge, to say at least constructive knowledge, it rather illustrates the laborious nature of this process of going through these requested findings.
Yes, my lord, exactly. It seems not really to hold together, but I thought I should draw all three.
Yes, fair enough. Thank you.
The final matter that was raised yesterday that I had a note to follow up on is about how dishonesty was pleaded. And you may remember that we looked at particulars of claim paragraph 111, which refers to paragraphs 28 to 99 compendiously, particulars of claim. And I've searched for and not found any reference to honesty or dishonesty in those paragraphs. It seems that, as I think we rather assumed yesterday, they simply set out the facts rather than making any specific allegations tied to dishonesty. My learned friend, of course, will no doubt correct me if I've overlooked something, but I don't believe there's anything in there that makes a further specific allegation of dishonesty.
Yes, thank you.
Moving on then to ground 3 of the appeal, which relates to the proprietary claim. It would be helpful, I think, please, if we could start by looking at the way this is pleaded, which is in the core bundle at page 271. You'll see here the heading proprietary claim. It says the 2.2 million termination fee was a sum properly due and payable to the fund. The individual defendants acting without the authority of the fund procured that the diverted sum was ultimately paid to their corporate entity RRL. Paragraph 102, as we start to get into the guts of it. The fund's contractual entitlement to the termination fee payment is to be characterised as a debt to the fund, the debt, which is a shows in action in which the fund had a proprietary interest and in which FIML now has a proprietary interest as assignee of the fund's claims. Now, in my submission, what seems to be pleaded here is not a pleading of an equitable proprietary interest, it's simply a property right. Now, this might give rise to potential for, say, a restitutionary claim, though of course none is pleaded. It doesn't set out that there was any equitable proprietary interest in a debt, which would indeed have been a surprising allegation if made. But nonetheless, at paragraph 103, the claimant proceeds to say that in the premises, FIML is entitled to trace its property in the debt, or rather part of it, into the diverted sum paid into the bank account. Now, this might be a claim for a common law tracing claim, potentially, except, of course, that common law tracing won't help the respondents here because it's paid into the IRL bank account, which was a mixed fund. Private law, one can't trace through a mixed fund. Indeed, I think there's authority that says you can't trace through even through the banking system itself. But either way, a common law tracing claim is no good to them. And the way this is put here does not give rise to an equitable proprietary claim. And paragraph 104 goes on to plead that the sums were further transferred into the individual defendant's bank accounts, and a very small sum was left with IRL. And then paragraph 105, it says, in the premises, IRL, as the initial fraudulent recipient of the diverted sum, in which regard see paragraphs 116 to 121 below, holds the diverted sum or part of it, or some or all of the debt's traceable proceeds on constructive trust. So this seems to be a remedy for an equitable proprietary right, relying on the fact that IRL is an initial fraudulent recipient. And so we look to paragraphs 116 to 121, which is what's referred to, and that's on page 275 of the bundle. And we come here to the pleaded claim in knowing receipt. And it seems to me the relevant passage here is that paragraph 117, this is the part that relates to IRL. IRL knew, by reason of being fixed with the knowledge of the individual defendants, that it received the diverted sum in breach of fiduciary duties such that it is unconscionable for it to retain the benefits of the same. And if you then look on to 119, it refers to the individual defendants. 120 just sets out the relief that's being sought. 121 says FIML is also entitled in its own right as the fund's fiduciary with a duty to account. The same remedies as assignee. So if we go back to paragraph 105 of the pleading, we can see that the equitable proprietary remedy seems to be pleaded simply on the basis that IRL is a fraudulent recipient. But of course, there's no pleading of fraud against IRL. What's relied on is simply the fact that it, on their pleading, had knowledge of what they say was the fraud by the individual defendants. If we then look at, I can invite you to close that bundle and open the supplementary bundle. Find my references. The second supplementary bundle, I'm afraid it is for me, I hope it is for you as well. And this is the way the claimant put its claim in its trial case and argument, and that's at 373. And you'll see on page 373, paragraph 106, towards the bottom of the page, C brings a proprietary claim against each of the Ds in respect to the diverted sum. To do so, C must first establish that a trust has been constituted in relation to the diverted sum, and then that the trust has been breached. And that's a more standard way of putting an equitable proprietary claim, but not one in my submission that really reflects what has been pleaded. C may then pursue a proprietary remedy in relation to the diverted sum or any property representing it. And then so that seems to be a more orthodox basis for the equitable proprietary claim. But what follows, 108, a constructive trust exists over the diverted sum and its traceable proceeds on the following basis. 108.1, the RFC payment was a sum contractually due to the fund. The fund did not give its informed consent to the payment being diverted. The fund's contractual entitlement to the RFC payment is to be characterised as a debt. Where a debt is enforceable at common law, it constitutes legal property. It says, where a third party procures the debtor pay the debt to themselves or another person rather than the creditor is entitled to trace its property at common law into the debt. And then it concludes, the fund is entitled to trace its property in the part of the debt it has not been paid, by the diverted sum, into the diverted sum itself, and then into the hands of any recipient holding that sum or property purchased with it. So in their opening skeleton, they set out initially the basis for an equitable proprietary claim, but then seem to proceed and reverts to the debt analysis, which might give rise to a common law claim. In the claimant's written closing submissions, and this is now at page 523, same bundle.
For me, unfortunately, so give me a moment.
I'm sorry.
Sorry, can I just take that again, the page number?
523, the supplementary bundle, in whichever volume it's found. So these are the claimant's closing submissions. And paragraph 226, he brings a proprietary claim. 227, to do so, C must first establish that trust has been constituted. This repeats the wording of the opening, the claimant's opening. 228 repeats the fact that the loan was a debt, which was an asset of the fund. 229, it now says a transaction purportedly entered into by an agent, including by a company director, without actual or apparent authority is ineffective and in that sense void. Accordingly, at least where the transaction involves the transfer of property formerly owned by a company or held on trust by it, it's been held that equitable title will not pass with the result that the recipient will hold the property on constructive trust with the company. But where there's a prior fiduciary relationship, such as a director acting for a company, then that's not surprising that submission should be made. 230, further, where property is transferred without consent, including where consent was fraudulently procured, that property will be held on constructive trust by the recipient for the original owner. And this references for the first time Westdeutsche Landesbank. And this is then, in my submission, yet a new basis for advancing the proprietary claim. This was not in the particulars of claim, it wasn't in the claimant's opening. It is mentioned here in a single paragraph and in a footnote.
Can you help me with one thing? Why are we talking about debt here? I mean, maybe it's for Mr. Jones to say, but I understood that the money went into the client account of the fund's solicitors. The debt was paid, so far as the football club was concerned. I mean, yes, it may have owed a debt, but the debt was paid to the solicitors for the fund. And
well, I think Mr. Jones would have to answer that, but what I would say is even on their analysis, the analysis doesn't go towards supporting the equitable proprietary claim in respect of which they're seeking a remedy.
right, okay, but right, okay.
I think Mr. Jones would have to explain how that, or how any actions, how the money actually flowed, how that would even work in principle. But what I say is that in principle it doesn't support the claim that they make as a matter of law.
This wasn't actually a case in which, as I understand it, maybe I've got this wrong, but it wasn't actually a case in which a debtor was induced to pay the debt to a third party. As I understood it, the debtor paid the amount, this is why I want to see the documentation which is in that file, but as I understand it, the debtor paid the money to the solicitors for the fund.
That's correct.
And then the money held in the client account of the solicitors was remitted other than to a bank account of the fund.
That's correct.
Sorry, okay.
Yes.
Well, sorry, I was just making sure I'm not missing something here.
No, that's correct. So how the debt analysis works on any view is hard to understand.
Well, at least the first bit of it. I mean, I just wasn't sure why we were focusing on. I mean, and to say that you have to establish that trust was constituted in relation to the diverted sum, well, undoubtedly the solicitors did hold the money in their client account upon trust, I would have thought. But nobody suggested that the solicitors breached their trust.
Well, that's not quite right, because in their respondent's notice, for the first time, the respondent has now advanced the basis that the solicitors acted in breach of trust. And they seek to recover the proprietary claim on that basis, but that, of course, doesn't feature anywhere in the pleadings. It didn't feature at trial.
Oh.
So at the moment, I'm just looking at what, I will come on to that, I'm just looking at what happened at trial to finish this corner. Not. And so in oral closing, the defendants addressed the authorities referred to in the claimant's written closing in support of the proprietary claim. And we don't need to go there, but the references at S647 to 648. And even in respect of this new Westdeutsche claim, the defendant submitted that the claimant's authorities were all fraud cases, and whereas the claimant at trial seemed to be advancing the proposition that simply where monies were paid out without authority, and where there was no fraud, then that gave rise to a constructive trust. So that was addressed by the defendant in closing, even though it seems only to have appeared for the first time in the claimant's closing submissions at trial. So with that background, can we now please look at what the judge found at paragraph 445 of the judgment? Please do put that under the ring. you'll see at 444, the fund proposed an issue. Did the fund have a proprietary interest in the diverted sum? And the legal finding that the terms of the facility entitled the fund to receipt of a termination fee that include the diverted sum upon full redemption of the loan. The fund had a proprietary interest in that debt, and therefore in the diverted sum ultimately paid and its traceable proceeds. That is a very wrapped up finding that's being sought. And the judge simply says, in the circumstances of the case, and in particular the receipt of the US 1.1 million diverted sum, I am able to make finding 9.1 sought. First of all, there's no analysis of what's going on. In fact, in this whole section, it's notable that there's no reference to authority. And of course, the finding sought is to say that the fund had a proprietary interest in the debt. Well, as I mentioned a moment ago, the fund might have an ordinary proprietary interest in the chosen action, but what the judge did not find is that it had a pre-existing equitable proprietary interest, so as to enable it to invoke equitable tracing rules. The judge then goes on to say, do they hold the diverted sum?
Sorry, again, wait a minute. The fund is owed the debt by the football club. I mean, it is the legal and equitable owner of the debt. There's nobody else interested in the debt. I mean,
exactly, it's not split.
That's right.
There's no equitable, separate equitable interest.
But it doesn't mean that, in a sense, it couldn't assert an equitable claim if, just like with any other asset, if an asset of which you are the legal and beneficial owner is stolen from you, I'm not at the moment understanding why your claims are limited to a claim in law just because the legal and equitable title wasn't split at the start.
Well, I will come on to that, but I think the essential point is that if there is this exception, this Westdeutscher exception to the usual rule, which is that there has to be a pre-existing trust or fiduciary duty, and that is, we say, where monies are taken by fraud, and that is the matter that the claimant alluded to in its closing by reference. And what we say is that there was no relevant fraud in this case. And the claimant seems to go even further than that and say if simply it's taken without authority in some way, then this gives rise to an equitable claim. And we say that's not correct. So looking back to the judgment at paragraph 449, the fund invites the following finding. At paragraph 449, the judge makes the fair point that there's no allegation that the fourth and fifth defendants, FIR and Mrs. Diallo, procured consent to the diversion by fraud. He just says that they received the diverted sum as volunteers, and on the evidence neither was entitled to any payment. And then at 450, the judge says, as regards Mr. Churchill, Mr. Diallo and Mr. Nuseibeh, they were not honest in the respect found above. They did not procure consent to the diversion by fraud, but they did procure the diversion by fraud. That is another statement by the judge which doesn't identify what the relevant fraud is said to have procured the diversion. In the claimant's trial allegations, of course, it said that Mr. Mutazo Taibbi had been subject to the bonus fee misrepresentations. And that might have been, not the judge identifies it, but it might have been a basis on which you would say these monies were diverted by fraud. But of course, the judge held that those representations were not made. The judge entirely dismissed that part of the claim. And so here we have a statement that the individual defendants procured the diversion by fraud without identifying what the fraud is. And it's certainly not apparent what that fraud might be.
Well, isn't he saying that they, on his findings anyway, they knew that the money was supposed to go to the fund, they knew about the net asset value clause, so that the money wasn't supposed to be paid out, but they procured that it wouldn't get to the fund because they didn't have faith in the trickle-down theory. I mean, that seems to me to be what the judge is saying. You may say those findings are wrong or fail to take account of other matters which would have led to a different conclusion. But I mean, that must be what the judge is saying here, isn't it?
Well, that seems to be in very general terms, one assumes what he's relying on, though he doesn't say so. But that's not procuring the diversion by fraud. That suggests that there's a fraudulent act, such as a misrepresentation, that has caused the diversion of the monies. But
why is it not procuring it if you, give instructions to the solicitors holding the money to pay it into an offshore bank account for your own benefit? Isn't that just a type of theft or misappropriation of assets? Assuming it's made good on the facts.
it's assuming it's made good on the facts. Well, the solicitors were not, by submission, the solicitors were not misled. No one was deceived.
Well, it doesn't. They may have been by their own lights. They may not have been. But if the position is, as the judge seemingly did grope his way towards finding, the three individual defendants procured the payments to be made by the solicitors, perhaps innocently from their point of view, to a destination which was never authorized by the fund. Why is that not one of the myriad ways in which a misappropriation of an asset can take place?
But at the moment, we're speculating as to the basis on which the judge made this finding, because he doesn't set out what fraud is or how he.
There are acute difficulties in trying to get
how it actually comes about, or what the fraud is said to be, so that we are in a position to say whether, on a proper analysis, this is a relevant fraudulent act, and that's one of the difficulties with simply saying they did not procure consent to the diversion by fraud. They did procure the diversion by fraud. Leaves that question very much open. It's difficult to have what seems to be a finding of fraud, but without identifying who exactly did what and what it relates to.
Well, that just leads to the point. We have to do the best we can to obviously look at the judgment as a whole, including the judge's findings in relation to dishonesty, which we were looking at yesterday. And one can't compartmentalize it,
Well, I would simply say that there's no acts of procurement, or the relevant fraud is not identified in the judgment. And in my submission, the only place one would naturally find this is in the bonus fee misrepresentations, which the judge did not find. And of course, this is the reason why this is particularly difficult, is that the claimant didn't plead this Westdeutsche type basis for its proprietary claim. So one can't even assume that the judge has somehow accepted the pleaded case. One can't even go back to the pleadings and say, well, this is the fraud relied upon, and one would infer that that's what it was. It simply seems to come out of the blue somewhat, certainly in relation to the pleaded claim, and relies simply on a legal argument advanced. It was virtually the last point raised in their closing on this aspect. It's a sort of a secondary argument advanced in closing, but not by reference to specific acts.
One difficulty about this case is that the claimants set out to prove a conventional fraud case in the sense of the bonus fee misrepresentations, which the judge rejected. On the other hand, the defendants set out to say that there was the profit share agreement which entitled them to this money, and the judge rejected that case as well. So he's in an area of making factual and legal findings where he has rejected both sides' primary case, which no doubt made things difficult for him and meant that presumably the submissions which he received were not ultimately tailored to the factual findings which he was then going to go on to make. Because
one can certainly have sympathy for the judge, as I said yesterday, having made a central finding that Mutaz was fully informed and engaged in the diversion. That changes the whole landscape, absolutely. It shifts the whole position. But in my submission, what the judge should do at that point is not to say, and this is where our point about the procedural unfairness comes in, is not simply to sit down anew and say, well, in this changed landscape, I'm going to think about how such a claim might conceivably be put together, although in fact, in my submission, he doesn't really explain how that works either. What he should do is to go back to the pleaded case and say, well, what case is put here? And is it made out?
I mean, that's one of the core functions of pleadings, is to make sure that the case doesn't spiral off into ill-particularized and ill-thought-out variations on a theme which has never been properly pleaded in the first place.
Because certainly the West Deutsche point, if I can put it that way, so the stolen monies point, there's really no sign of that in the pleadings. That only comes very late. And so this is why we say, and in fact but no, I don't think we need to go there, but we put the authority of Ali and Dink in the bundle. It's authorities 32, and the relevant paragraphs are 19 to 25, which simply makes the point that the judge should decide the case put in front of him and not go outside the parties' pleaded positions. So,
well, I mean, wait a minute. It's quite often the case, shocking though it may seem, that neither side tells the whole truth, and judges end up making factual findings which don't wholly correspond to one side or the other. I mean, a judge could certainly do that. I mean, your point, I think, though, is that having found that the facts, as it were, that neither side has told the truth, the whole truth, and nothing but the truth, the judge then needs to look at whether the pleaded case is established on the facts that he has found.
yes, the
So
judge...
the judge can go outside to that extent, the pleaded case, in the sense that he's not obliged to say, I must accept one side.
No, of course, that's right. But it still has to be within the bounds of what was in dispute at trial. And what's in dispute at trial is bound by the pleadings.
Yeah.
And so if you look at the pleadings and say, well, here's a point that hasn't been run, then it's not really open to the judge to say, well, I put a different theory that not just a different finding of fact, but a whole different theory as to how this claim might be put together.
In other words, if, and presumably that's the justification for allowing people to plead in the alternative.
Yes, they could say there are many different ways. It would have been open to the claimant to say this arises in a number of different ways. Yeah. But I've taken you to exactly how they put it, which my submission is quite confused, but doesn't encompass what appears to be the basis on which the judge puts it. And the basis on which the judge puts it is so lean that it's very hard to see exactly what he's relying on or how he gets there.
And these points all reflect the, ultra basic point that our system is an adversarial one and not an inquisitorial one. So,
absolutely, and this is what Ali and Dink and the authorities there talk about. I should deal with what I'm calling the new basis for the respondent's proprietary claim, which is exactly the point your lordship has been talking about, which is that the monies, they say now in their respondent's notice, that the monies were paid to Burgess Salmon, who held them on trust, and were paid away in breach of trust, and that is the pre-existing fiduciary relationship which allows them to trace in equity. The first point to make is obviously this is not pleaded at trial. This wasn't pleaded. It wasn't something that was canvassed at trial.
Sorry, could you just remind me of where the respondent's notice is? Because I must admit this is...
I'm sorry, yes.
I don't have it right in my...
I'm sorry, it's core bundle 1. Should have taken me to it. Core bundle 1. It's tab 8. And it's page 77. Perhaps I'll just invite you to read paragraph 2, which goes on to the next page.
Sorry, this is core bundle tab 8.
Page 77. if your lordships have had a chance to read that. So you will see that this is a new claim. It's not pleaded. At the centre of this claim is an allegation that Burgess Salmon acted in breach of trust, which one might think of an allegation such as that were going to be made. Burgess Salmon might have a view, or might, if it had been raised at trial, might have wished to say something about that. But even taking the argument on its own terms, we say it doesn't work as a matter of law. Well, in fact, there are 2 points. The first really is that because it wasn't pleaded at trial, the judge didn't make findings as to the basis on which Burgess Salmon held the termination fee, or whether anybody else might have had a claim on that fee, or whether instructions Burgess Salmon might have had, which weren't already before the court, because it simply wasn't an issue. So it wouldn't have been an issue for disclosure, for example. It wasn't something that was canvassed. But perhaps, going to the essential point in any event, is that if you were going to say, well, did Burgess Salmon act in breach of trust, it must be that they did not act in breach of trust if they paid away the monies in accordance with their proper instructions. And that would mean that in this case, the instructions came from Mr. Nuseibeh to pay away the money, and Mr. Nuseibeh was authorised, or FCM London was authorised by the fund. Mr. Nuseibeh was authorised as an employee of FCM London to give instructions to Burgess Salmon in relation to this redemption. And so if one looks, for example, if I could take you to the authorities bundle, target holdings and red ferns, the authorities bundle tab 3,
Of course, we need to remember that the authority that FCM London had was to act in relation to all these matters without reference back to the fund. So from the point of view of Burgess Salmon, they were perfectly entitled to rely on...
This is the point I'm coming to with target holdings. I think strictly it was FIML were authorised to act without reference to the fund, but FCM London were authorised in this part of the chain. FCM London were authorised in this particular instance to deal with the fund, just to be clear on that point.
Yes.
So at target holdings, if we look at page 436, and about 4 lines down from A, he says, Dr. Brian Wilkinson says, in the case of monies paid to a solicitor by a client as part of a conveyancing transaction, the purpose of that transaction is to achieve the commercial objective of the client, be it the acquisition of property or the lending of money on security. The depositing of money with the solicitor is but one aspect of the arrangements between the parties, such arrangements being for the most part contractual. Thus, the circumstances under which the solicitor can part with money from client account are regulated by the instructions given by the client. They're not part of the trust in which the property is held. This, one might say that this is obvious in a situation such as this, that the Burgess Salmon did not act in breach of trust if they complied with instructions from the person who had been authorised by the fund to give them those instructions.
I mean, to put the same point in a different way, they're actually carrying out the terms of the trust.
Yes, they would arguably be in breach of trust if they failed to carry out those instructions.
Yes.
And so even though I say this is a point that the respondents simply can't take at this point, this isn't just a technical point. The substance of their point is not good either, which is that Burgess Salmon acted on instructions from a person who was properly authorised to give them, and so did not act in breach of trust. And so that new way the claimant, the respondent, has of putting its proprietary claim also cannot succeed.
I mean, is this right? I mean, you haven't taken us to West Deutsche, and I can't remember the exact wording of West Deutsche, but would the factual inquiry as to the state of mind of the individuals be different if what was alleged was that the relevant breach of trust was that of the solicitors rather than anything else? I mean, it goes back to some of the questions I was asking yesterday. if you are dishonest in committing a fraud, as to use very general language, but the mechanism through which the fraud is committed is a firm of solicitors that you induce to make a payment, the line of questioning is presumably different than if you are accused of committing a fraud where money doesn't go anywhere near a sort of firm of solicitors who are not the obvious target for a fraud.
I think there are two different ways in which the proprietary interest can arise. And as it were, the normal one is where there's some pre-existing fiduciary or trust relationship and money is paid away in breach of fiduciary duty or in breach of trust. But there is in West Deutsche, I mean, it is itself not wholly free from controversy, but there is a proposition where he talks about the bag of stolen coins and says that monies procured by fraud are also held on constructive trust. And that's the sort of grey area that the respondent is now trying to fall into. So that element doesn't apply to the Burgess-Salmon, the new Burgess-Salmon claim. That's sort of orthodox, pre-existing trust relationship. They would have to show that Burgess-Salmon acted in breach of trust, and then, subject to equitable defences, they could trace at equity their property through the various accounts.
Yes, I mean, it's not quite. I'm groping rather badly for the question. It's that normally, if you see a fraud committed, it's because somebody tricks or induces a trustee to pay money to them, or indeed they are the trustee and they just go ahead and pay the money in a disguised fashion to somebody themselves or somebody else. The line of factual investigations to the state of mind of the defendant in those circumstances is very different than or could be very different than if the relevant allegation is the relevant disposition is by a firm of solicitors. Because often people would say, well, the defendants would often say, well, hang on a second, if there was something wrong with this, I would have expected the firm of solicitors to tell me that there was something wrong with this.
Well, certainly.
They never said.
The fact that it wasn't pleaded.
That's the point. I mean, because it's not pleaded as a diversion from a firm of solicitors, from the client account, the relevant line of questioning, I suspect, might have been very different.
Well, the questioning might have been that if they were saying, well, this has been fraudulently procured in the West Deutsche sense, then if there were a pleading as to how it had been done, it might have been possible to challenge the relevant fraud as to how it was put. But because it wasn't pleaded exactly how this fraudulent procurement was achieved, there wasn't an opportunity, in my submission, even to challenge that in the context of the proprietary claim. Of course, I accept that in broad terms, all kinds of different aspects of fraud were advanced at trial. But in relation to the proprietary claim, you need to know, if the claim is brought that these monies have been procured by fraud, the very least the defendant needs to know is what's the fraud of which he's accused, the relevant fraud relating to this diversion. And that's never been established either in the pleadings or indeed by the judge. I'm conscious of the time, so if I may, I would like to move on to unlawful means conspiracy. Let's start, please, by looking at the judgment at page 4, paragraph 481. The allegations are then made against Mr. Nuseibeh and then Mr. Diallo and Mr. Churchill are also allegations I reject. Sorry, this is in relation to some of the other causes of action. But they go principally to the case of conspiracy in relation to the alleged non-payment of what the fund terms the missing termination fee payment rather than diversion of what the fund terms the diverted sum. In the latter instance, so in terms of the diverted sum, the unlawful, sorry, I'm sorry, I've skipped a little. It starts at 476. These are the fund's claims of conspiracy, where the judge starts by summarising the law as set out in Clark and Lindsay. The findings are sought by the claimant, as we've seen, and the judge then says, I can deal with those in the following way. He says, I find that the individual defendants combined to take action that ensured that the fund did not receive the US 1.1 million. I reject the allegation that the fee was just over 3 million. So that's a combination. And then, of course, we have to look for what is the unlawful means that they've taken, which has resulted in this sum being taken. And the judge at 481, the last sentence, simply says, in relation to the latter instance, that is the diverted sum, the unlawful action was the diversion itself and to themselves of money due to the fund. So the first point is simply to say this is a recurring theme in my submissions. We look at the judgment and we say, well, what is the relevant unlawful act being relied upon? And because some unlawful acts, such as breach of fiduciary duty, the judge found the individual defendants owed fiduciary duties. And if that's right, and the judge had found a breach, then that might be one thing. But the claimants, respondent, now seem to say that the unlawful act can be spread very wide. It could be even as remote as the individual defendant's breach of their duty of fidelity to FCM London. And in such a case, it's very difficult to see how that gives rise to an unlawful means conspiracy. So my first point is simply the way it's put in the judgment doesn't enable us as the appellants or the court really to see what the proper basis was for the judge's finding. But the second point is that really relates to the intention. So it is, of course, as set out in Clark and Lindsay, strike law that for unlawful means conspiracy, there must be an intention to harm the fund. Now, that intention, of course, is not a predominant intention as it is in the other form of the tort. There still must be an intention to harm. And the respondent makes the point quite rightly that it needn't be an express intention to harm. It can be sufficient intention if the wrongdoers intend to profit themselves, but it necessarily follows that it will cause harm to a third person. But in this case, our submission is that there was no intention to harm the fund. And this really comes back to the submissions I was making yesterday, because the individual defendants did not believe that the fund would be harmed at all. They believed that the monies would be paid out to FIML. So if the diverted sum had been paid to the fund, it simply would have been paid to FIML, as won't take the lordships through all that material again, obviously, but it's really the same point. If they believed that the sum was properly due to FIML, there's no harm to the fund in the fact that it didn't go there immediately and was instead took the shortcut. At one point in their submissions, the respondent even seemed to suggest that it doesn't matter if the individual defendants did not actually intend to harm the fund. And I should just say, in my submission, that's wrong as a matter of law. It's well established there must be an intention to harm. Although, as I said a moment ago, I accept, of course, that intention needn't be an intention, sole or predominant intention, and it can be a reflected intention where there's an intention to benefit yourself, and the flip side of the coin, as it's put, is that somebody else will inevitably be harmed. If I take money from you, even if I have no ill will towards you at all, it's obviously the case that you will be harmed. But this is not that situation. This is a situation where there was no intention to harm the fund, because this was money, as they all gave evidence to say, that they believed would not end up with the fund. It would just be paid straight through to FIML as profit. And so really for those two reasons, just dealing with this point shortly, first, because the relevant unlawful means is not even identified or properly identified to found it. And secondly, because there was no relevant intention, because they had no belief that the fund would be harmed. And indeed, as we saw with the 2019 payment, the evidence suggests that the fund was not harmed. I would like, please, to move, unless I can assist your lordships any further with that particular point, I would like now to move back to ground one, which is relates to fiduciary duties.
Just out of interest, I mean, I understand why the factual, why the findings that the judge was invited to make didn't refer to Mutaz. But consistent with what the finding the judge did make about Mutaz's knowledge of the payments, it must have followed that he was a conspirator as well, presumably.
One would assume so, but of course no claim was brought against Mutaz by anyone on that basis. But yes, the fund found that he gave fully informed consent.
But because
the judge found he gave fully
because the judge is just going down a multiple choice list, as it were, of findings, Mutaz doesn't feature as one of the co-conspirators because that wasn't suggested by the claimant, but it would follow logically from his findings, I think.
I would say that must be right, but of course that wasn't the fund's case at trial. Nor, of course, was it the defendants or our case.
No, I understand I understand fully your case, but it's just the finding that he makes.
Okay. This may be an example of addressing one part of the issue without going back to say, well, what other findings have I made along the way? We simply don't know how this judgment was put together. It may be that you embark on writing one part of the judgment and then once that's written, it hasn't been reviewed in light of the key findings in respect of Mutaz that were made subsequently, but that's obviously just speculation. But that goes to what we've called our general ground of appeal, which is from the judgment itself and from the delay and from what appears to have been the piecemeal writing of the judgment over a long period of time, these kinds of errors creep in.
Right, ground one.
Ground one.
Judicial duties.
There are two aspects to ground one, and the first is that we say the judge was wrong to find that the individual defendants owed fiduciary duties direct to the fund. And the second part of it is we say the judge was wrong as a matter of, wrong primarily as a matter of construction of the investment management agreement, to say that Thimmel owed fiduciary duties direct to the fund. I'd start by dealing with the individual defendants. And just look at the pleadings of how it's put. It's helpful. And that's in bundle C at 237. So the claimant puts it this way, that Mr. Churchill and Mr. Nuseibeh owed fiduciary duties to FCM, and all three individual defendants owed fiduciary duties directly to the fund. Mr. Diallo is, of course, missing from the first part, because in the previous paragraph, as a director of FCM London, it's uncontentious that he owed, or in principle, owed fiduciary duties to FCM London. So in this paragraph, the claimant says all three individual defendants owe fiduciary duties directly to the fund, in each case arising out of their contracts of employment with FCM, and in each case in respect of their particular roles managing the redemption of the loan facility, such that they were expected, amongst other things, and there follows some of the usual incidents of fiduciary duty: show undivided loyalty, not to profit, not to place themselves in a position of conflict of interest. And the basis on which this is put is, it says, so paragraph 22 begins for the following reasons, and then the reasons are in the numbered subparagraphs. So 22.1 is they were expected to subordinate their personal interests to those of the fund when negotiating with RFC and instructing Burgess Salmon. The circumstances in which the individual defendants managed the redemption of the loan facility gave rise to a relationship of trust and confidence. So that's relying on the various factual matters pleaded subsequently. The fund and FCM were vulnerable to the individual defendants misusing their authority. The fund and FCM were reliant on the information or advice in respect to the disinvestment of the loan facility. And that's it in terms of the basis on which they're said to owe fiduciary duties to the fund. Now, I would like to take you just to a couple of authorities on this. The first is the well-known passage of Lord Justice Millett in Bristol and West, which is at Authorities tab 5. And the relevant passage is at page 190. Where Lord Justice Millett makes a very good attempt at defining a fiduciary, saying a fiduciary is someone who's undertaken to act for or on behalf of another in a particular matter and circumstances which give rise to a relationship of trust and confidence. The distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to the single-minded loyalty of his fiduciary. This core liability has several facets. The fiduciary must act in good faith, he must not make a profit out of his trust, he must not place himself in a position where his duty and his interest may conflict. He may not act for his own benefit or the benefit of a third person without the informed consent of his principal. This is not intended to be an exhaustive list, but sufficient to indicate the nature of fiduciary obligations. As Dr. Finn pointed out, he is not subject to fiduciary obligations because he is a fiduciary, it is because he is subject to them that he is a fiduciary. That's the classic statement. Could we next please look at Al Nehayan in Kent, which is at Authorities tab 22. And the passage I rely upon starts on page 661. At paragraph 141, you'll see the heading terms expressly agreed between the parties. This is Lord Justice Legos. In assessing the nature of the parties' relationships, the starting point must be to identify what was expressly agreed between them. And then he cites Mason J. in the High Court of Australia, saying that contractual and fiduciary relationships may coexist between the same parties has never been doubted. Indeed, the existence of a basic contractual relationship has in many situations provided a foundation for the erection of a fiduciary relationship. In these situations, it is the contractual foundation which is all important, because it is the contract that regulates the basic rights and liabilities of the parties. The fiduciary relationship, if it is to exist at all, must accommodate itself to the terms of the contract so that it is consistent with and conforms to them. The fiduciary relationship cannot be superimposed upon the contract in such a way as to alter the operation which the contract was intended to have according to its true construction. And obviously I'm going to rely on this when we look at the chain of contracts which was put in place to say that the individual defendants at the end of this chain from the fund would not owe fiduciary duties directly to the fund, as it would be contradictory to the contractual structure put in place. And so at 142, he says there are two important points to note here. First, what the parties have contractually agreed may determine whether their relationship is of a fiduciary nature. For example, whether they've entered into a partnership or one has agreed to act as agent for the other. Second, where the parties are in a fiduciary relationship, the scope and content of the fiduciary duties owed by one to the other will be shaped and may be circumscribed by the terms of the contract between them. That's the point about the contractual part. And there is then also a long discussion about fiduciary duties generally at paragraphs 153 onwards. And I think I would simply invite you to read about 4 paragraphs. Starting at, well, the background is at paragraph 156 on page 666, where the judge says, on behalf of Mr. Kent, Mr. Lewis submitted that, as in these cases, the parties in the present case were joint venturers who reposed a high degree of trust and confidence in each other. And he was seeking to say that his joint venture partner, Sheikh Tanoon, was under a fiduciary duty to provide him with funding as it was required. Now, 157, Lord Justice Leggett starts by saying, in considering the submission, I bear in mind that it is exceptional for fiduciary duties to arise other than in certain settled categories of relationship. I just invite you to read the rest of paragraph 157. (158) then refers to Lord Justice Millett in Mothew, and indeed also refers to Mason J. in the High Court of Australia in the Hospital Products case, which you've just seen. And then at 159, Lord Justice Leggett says, thus fiduciary duties typically arise where one person undertakes and is entrusted with authority to manage the property or affairs of another and to make discretionary decisions on behalf of that person. Skipping the brackets, at C, the essential idea is that a person in such a position is not permitted to use their position for their own private advantage, but is required to act unselfishly in what they perceive to be the best interests of their principal. This is the core of the obligation of loyalty, which Lord Justice Millett in the Mothew case describes as the distinguishing obligation of a fiduciary. Loyalty in this context means being guided solely by the interests of the principal, not by any consideration of the fiduciary's own interests. If I can invite you then to look at paragraph 163. Counsel for Mr. Kent placed heavy emphasis on the close personal relationship and for the fact that for most of the period of their business association they reposed a high degree of trust and confidence in each other. But the existence of trust and confidence is not sufficient by itself to give rise to fiduciary obligations. In the first place, the question whether one party did in fact subjectively place trust in the other is not the test. And then at 164, he carries on to say, it's also necessary to identify more precisely the nature of the trust and confidence, which is a feature of a fiduciary relationship. There plainly are many situations in which a party to a commercial transaction may legitimately repose trust and confidence in another, without the other party owing fiduciary duties. Reference to Re Goldcorp Exchange. And he continues at paragraph 165. Mutual trust and confidence between the parties dealing with one another can be of different kinds. At a basic level, any contracting party is entitled to rely on the other party to perform its contractual obligations without having to monitor performance, or even if, as in Re Goldcorp, it's unable to monitor performance. The kind of trust and confidence characteristic of a fiduciary relationship is different. As discussed above, it is founded on the acceptance by one party of a role which requires exercising judgment and making discretionary decisions on behalf of another, and constitutes trust and confidence in the loyalty of the decision maker to put aside his or her own interests and act solely in the interests of the principal. So in the first part of that paragraph, I rely in particular on the fact that you're entitled to rely on the other to perform its contractual obligations without monitoring them or without being able to monitor them. But that is not in itself enough to give rise to a fiduciary relationship. The respondent also relies on a couple of other cases which discuss fiduciary duties in the context of a joint venture. Perhaps I'll leave my learned friend to take you to them if he wishes. He refers to Ross River, which also quotes the same passage from the High Court of Australia and Hospital Products, and also relies on Farrer and Miller, which makes a very brief summary of the law. So moving on to how this applies to the individual, I can like to put the authorities bundle away. Moving on to how this applies to the individual defendants. The first point we make is even before one gets into analysing whether the judge might have been right to find that fiduciary duties were owed, is the fact that when one looks at his judgment, it seems that he did actually reach a reasoned conclusion that the individual defendants did not owe fiduciary duties. And it was only subsequently that he found, without reasons, that those fiduciary duties had been breached. So this is dealt with in the judgment at paragraph 417 onwards. So at 418, the fund had asked the court to make findings that neither the fund, Fimmel, or Mutaz had any real oversight of the individual defendants in relation to their dealings with Burgess Salmon and the redemption of the loan from Reading, which, of course, I would say, from what we've just seen, is certainly not enough by itself to give rise to a fiduciary relationship. And the judge at 419 says this: I'm able to make finding 11.1, but with an important exception. This is that, save in one respect, communications with Reading FC and Burgess Salmon, and reports on how the redemption and cash flows are being handled, were by FCM London. That FCM London, acted by Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh's employees, does not alter that position. Only communications and reports concerned to alter the destination of the termination fee in the interest of the individual defendants were made by Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh acting on their own behalf. But here, of course, we are looking for a pre-existing fiduciary relationship. So in terms of how this was set up, it was FCM London that was acting for the fund in terms of the redemption. The judge holds at subparagraph A, 420A, the fund gave its consent to FCM London taking steps on behalf of the fund in relation to the redemption facility. This consent did not extend to steps concerning to alter the destination of the termination fee. The steps taken on behalf of the fund in relation to the redemption of the facility were taken by FCM London, acting by Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh as its employees, save for those concerned to alter the destination of the termination fee. At 422, the judge refers to various of the relevant authorities cited to him. And at 423, the judge dismisses the idea that the individual defendants owed duties to the fund by reason of their employment with FCM. There is no question that simply by being employees of FCM London as investment advisor, the individual defendants had a relationship with the fund, let alone one of trust and confidence that was fiduciary in nature. The fund's relationship was with Fimmel, or perhaps with FCM London. So there's a clear finding there that they did not have a relationship with the fund by reason of being employees of FCM London. At 424, the judge avoids temptation. He avoids the temptation to find that a fiduciary duty is owed just at the point where it's breached, and he was correct to do so. It's tempting in the particular circumstances of the case to reach a different conclusion at the point from which the individual defendant set about to alter the destination of the US 1.1 million. But as the present case illustrates, that is the point at which the obligations of any relationship were not honoured, and the first question is when there was a relationship. So he rightly reasons that the breach does not give rise to fiduciary duties. It's unsurprising. At 425, the judge refers to academic opinion an article by Dame Sarah Worthington, Honorary King's Counsel, to the effect that conscious wrongdoers do not owe fiduciary duties, as he summarises. I don't think he's intending to summarise the entire article, but at the end of paragraph 45, he summarises. So, to treat the conscious wrongdoer as a fiduciary is only the start, because then the question of what fiduciary duties apply to that relationship arises. And this in a context where the concepts of trust and confidence, and especially confidence, are not an easy fit, unsurprisingly, if it only arises once something has gone wrong. At 426, it may be that the particular circumstances in each case will require different answers. In the present case, it is when the fund's proprietary claims and claims in dishonest assistance and knowing receipt are addressed that the legal ground sufficient for the present case is reached. Now, I have to accept that this could have been phrased more clearly, but in my submission, the judge is here finding clearly that the legal ground sufficient for the present case, in other words, the basis on which he's going to find that the claimants succeed, is not this ground that the individual defendants owe fiduciary duties. It's in relation to the proprietary claim and dishonest assistance and knowing receipt. And of course, those two claims are not founded on breach of fiduciary duty by the individuals. They're alleged to be either the assisters or the knowing recipients. And if there were any doubt about that finding, which after all follows on from the various factors he's analysed in the preceding paragraphs, that doubt is removed by the following paragraph, 427. Although in these circumstances it does not arise, the fund then seeks a finding in these terms, and the finding sought is that clause 13 of the investment management agreement, entitled waiver of fiduciary duties, does not in any way prevent a finding that the individual defendants owed fiduciary duties to the fund. So this question doesn't arise because in the judge's mind, and as set out at 426, he found that the individual defendants did not owe fiduciary duties to the fund. So he doesn't need to consider whether a clause of the investment management agreement would have the effect of waiving them. So that is, in my submission, his finding. And in fact, that's reflected a few paragraphs on, at paragraph 432, just over the page.
What's he trying to say in 429?
This
Second sentence.
second sentence. Well, I should point out that the first sentence, there's obviously a typo, which might be misleading. It must be, clause 13 in terms limits the duties and obligations that FIML owes, rather than the fund, whether arising from the fact that FIML is acting as the fund's fiduciary or otherwise. In the circumstances, I'm able to find that clause 13 of the investment management agreement does not prevent a claim against the individual defendants of breach of fiduciary duty if and where they owe fiduciary duties to the fund, and where such breaches were dishonest or fraudulent in nature. So,
I thought it's a bit curious that your contention is that he has clearly found that there is no such fiduciary duty.
yes, because this is under this is all under the legal finding 11.4, paragraph 4.27, sorry, 427, where he says, although in these circumstances it does not arise. Yeah. So this is, from making
why does he then find, having found that there were no fiduciary duties, why does he find, I'm not sure why he makes a finding in the second
He
half.
seems to be making it on an alternative...
hypothetical basis?
Yes, it's a hypothetical. It's on the alternative basis. Perhaps he's thinking, in case I'm wrong about that, as some judges sometimes say, I find that this clause wouldn't have the effect if and where they owe duties to the fund.
Oh, okay.
It wouldn't. And notice
so if I were wrong about whether they owe fiduciary duties,
then this clause
makes 13 doesn't help them.
Yes, I mean it would have been simpler given that this didn't arise. And it might have been simpler just not to have dealt with it at all. So it's possibly confusing. Except it does make clear that although in these circumstances it does not arise, that's the whole basis on which he's proceeding to consider clause 13. So I was just going to show you one more point at paragraph 432. And now this is in the context of the missing termination of fee payments, which of course the judge found against. the judge says, well, I do consider, as explained above, that Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh do not owe fiduciary duties to the fund in respect of missing termination fee payment. That is not because of clause 13. So it's another, he says it only in relation to the missing termination fee payment, but he refers to the, as explained above, in my submission, this is another part of the judgment from which one can infer, reading it all together, that the judge has reasoned his way to a finding that the individual defendants do not owe fiduciary duties. And like I say, we've seen that. He starts with authority at 422. He dismisses the argument that they arise by virtue of being employees. He dismisses at 423. He dismisses the argument that an act of wrongdoing can give rise to fiduciary duties. He dismisses the argument that they give rise simply because of being a conscious wrongdoer, and then concludes at 426. So this case is going to have to be founded on some other cause of action. So in those circumstances where he's made those findings, it's very surprising to find at paragraph 437 and 438, it says the fund asked the court to make these findings in relation to the US 1.1 million. Legal finding 12.2, Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh breached their fiduciary duties to the fund in procuring the diversion of the diverted sum from the fund. 438, I'm able to make these two findings sought by the fund. But there's no reasoning there. And in my submission, this is simply a result of a feature we've noted before, which is by dealing with these findings sought one by one, and not really stepping back sufficiently to say, well, what's the cause of action here? And say, do they owe any duties? And if so, if they breached it. He seems to be caught up with factual finding 12.1, which is that they procured the diversion of the diverted sum away from the fund, knowing that it was contractually due to the fund. Now, that was his factual finding, which, of course, we challenge in a different context. But it seems that he's wrapped up in his findings of fact. And then at 12.2, he simply says, I find that they breached their fiduciary duties. But it's not reasoned, and it doesn't follow in any way from what's gone previously.
Indeed, it's a direct contradiction.
It's a complete contradiction. They can't stand together. And we say, especially given that the earlier part is reasoned, and this is not reasoned. In my submission, it's clear, even without going into the principle of whether the individual defendants owe fiduciary duties, it's clear that the judge actually found that they did not.
Was this point raised with the judge when the judgment was circulated in draft? I know one's only supposed to make a return on typos, but if you do spot a direct contradiction in the judgment, it's usually a courtesy at least to let the judge know.
I'm afraid I cannot tell you exactly what was raised at that point, but the judge, of course, did give permission to appeal on grounds which included the ground that they did not owe fiduciary duties.
Well, yes, but one should try and sort these things out before it gets to an appeal rather than in this court. Yes. I mean, or if it appears to be just some simple oversight, then
it might
the
be
judge
better.
has apparently contradicted himself, as you say, having dealt with the matter at length and on a reasoned basis, then says the direct opposite without explaining himself.
I'm afraid as I wasn't at trial, I'm not able to help you on whether it was raised in the context of corrections. But yes, it appears to be a direct contradiction. So my primary submission is that
it might, if one were to pursue those points, not saying necessarily we should, but it might be relevant to know how long the judge gave the parties to read this 500 paragraph judgment before it was going to be handed down, and whether, as is, I think, often the practice in the commercial court, a draft notice of appeal was submitted at the hand down or the consequentials hearing, if there was one, which might have said that there were inconsistencies.
I'm not able to answer your first question, though I'm sure I can find out. As to your second question, my understanding is there was a draft notice of appeal, but I suspect it would have been in similar terms to the current notice of appeal, which doesn't specifically identify that point. It simply says, the judge was wrong in law in finding the first and second defendants owed fiduciary duties to the fund, but it does say, which was itself contrary to other findings at paragraphs 43 and 46 to 47, and wrong to fail to set out any reasons in support of such finding.
Okay.
And so it is, my learned junior points out that the draft judgment was received on the 4th of February and subsequently handed down on the 18th of February.
Right.
That comes from the new evidence, which your lordships have read, Defendant ASA,
Oh, right. Okay.
from the solicitor. So that's thank you. That answers the first question. And the second question is that I can't say that the ground of appeal was phrased in this way, but I understand there were draft grounds of appeal before the judge, so I will check that point.
Yeah. Okay.
So my primary submission is that is you should go with judge's own finding, in essence, and say no fiduciary duties were owed. I then have a number of submissions, which I will deal with relatively shortly, to simply say, well, if your lordships were concerned that there was simply a contradiction and you weren't satisfied as to which way it should go and were to be making this decision again for yourselves on the evidence. On that basis, I would then put forward the following reasons why, in my submission, the judge was in any event right to say that no fiduciary duties were owed by the individual defendants to the fund. And the first point, as I highlighted when looking at the authorities, is the contractual structure. There was no direct relationship between the individual defendants and the fund. The fund engaged FIML as investment manager, FIML engaged FCM London as investment advisor, FCM London engaged the individual defendants as employees. And we've seen that the judge rejected on a number of occasions the idea that instructions were given to the individual defendants rather than to FCM London. The judge repeatedly emphasised that delegation of this matter was to FCM London acting by its employees rather than to the individual defendants themselves. The references for that, just give you them in the judgment, are 124, 136, 390, 393, 419. And in fact, it was the respondent's pleaded case, paragraph 11 of its particulars of claim, that FCM London was engaged to deal with the redemption. So the first point is there's no direct relationship. The second point is the imposition of fiduciary duties would be contrary to the contractual structure. As we've seen in the Highland and Kent, the fiduciary duties, if they exist at all, must accommodate itself to the terms of the contract. And as we saw yesterday morning when going through the various contracts in the structure, there are various features of those contracts which would mean that imposing duties directly on the people at the very end of the chain would be contrary to the structure that the parties agreed should be set up. So we saw, first of all, that FIML, you may recall under clause 3.16 of the investment management agreement, it was FIML who had the power to appoint an investment advisor. The fund had no say where that advisor was an associate and only a power to agree or to approve such approval not to be unreasonably withheld, even if it were a third party. On that basis, it would be very surprising for the fund specifically to rely on some person it had not even chosen. There is, under clause 3.16, as we saw, a provision that says that FIML, when making any delegation or appointment, shall be responsible for the acts and omissions of its delegates as if they were its own. So there is a contractual way in which the fund, if it's not happy with the actions of FCM London, there's a contractual route for the funds to seek recovery. You will recall under the IMA that FIML and its associates, which included FCM London, were permitted to act where they had a material interest giving rise to an actual or potential conflict with the manager's duty to the fund. And that was replaced in my submission by a contractual obligation to take all reasonable steps to ensure the fund is treated fairly. That's the reference to that is S13. I'll give you the references, but I won't take you there since we did go there yesterday. Clause 5.5 at S13 excludes the essential fiduciary duties of no conflict and no profit. That's clause 5. And clause 10, S15, you'll recall that liabilities was excluded except in the case of actual fraud, gross negligence, or willful default. And even then, its liability was limited to 5 million. And then under clause 10.3 at S15, the fund fully indemnified FI FIML, its associates and officers, employees and agents from any loss, save as arose from gross negligence, willful default, or actual fraud. And so that provision, clause 10.3, extends even to the officers and employees of FIML's associates. So that would extend directly to the individual defendants as employees of FCM London. There are very similar provisions under the Investment Advisory Agreement. S33, paragraph 5.3 permits conflicts. Paragraph 5.5 permits the investment advisor to act for others and retain any fees or monies. You may recall there wasn't even a requirement to disclose relevant information.
If you're wrong on these points, and fiduciary duties were owed, notwithstanding the contractual framework by FIML or FCM, let's say, you still have your first point, which is that's the framework, and you don't reach down to employees of those companies.
Yes, yes, absolutely. The overarching framework we've seen, which is, it's contrary to the framework in my submission, taken as a whole, to say, here is a framework where we're all essentially, ultimately acting for the fund. And this person has various carve-outs and indemnities and so on, and so does this person, so does this person. But actually, the fund can go right to the end of the chain and pick on the individual employees.
Yeah, the point I'm making is there could be fiduciary obligations owed by the corporate entities.
Yes.
Structure, but still not by the individual employees.
Yes,
of the corporate.
Yes, absolutely. So
so this isn't an essential part of your argument on this first point. It is the point you're going to come on to on your second point.
It is, yes, when I'm talking about FIML's duties. But on this point, the mere fact that there are duties, if your lordships were to consider, for example, that FIML did owe some fiduciary duties to the fund, the fact is those fiduciary duties would still be, on any view, quite highly circumscribed, looking at clauses 5 and I would say 13. To impose uncircumscribed duties on another element of the structure, sort of bypassing all those protections that the parties clearly intended to put in place, in my submission would be contrary to the overall agreement of the parties in putting that structure in place. So whether the fiduciary duties are waived completely, or whether waived in part, or whether even, in this case, even when there's simply a cap of 5 million on liability, what would be the point of the parties agreeing such a cap if at any point the fund could simply say, well, I know it says that in this agreement, but I can just pick an employee of any one of the other people further down the chain in order to avoid that.
Yeah, well, you could put it another way. It's an indication that no fiduciary duties were intended to be assumed by employees of, let's say, of FIML or FCM. And the fund would not have anticipated that it would be owed such duties because it made no contractual provision.
Yes, it made no...
in that regard, whereas it did make contractual provision to some extent in modifying the duties of the corporate entities.
Yes, the fund set in place, agreed to this structure where it would have rights against FIML, and it had rights against FIML in relation to the acts of its delegates. So that was the way in which the fund imagined that it would control structures, not that it would have directly enforceable rights against the employees of a third party it had not even appointed. The idea of reliance in that sense, or a kind of relationship of trust and confidence in that sense, seems unlikely. So we've, just to conclude this, so that's the contractual structure as a whole. These details of the contractual structure are just ways in which imposing unrestricted fiduciary duties on the individual defendants would be contrary to what was agreed. So the fact that unrestricted fiduciary duties would not have a liability cap, they would not have an indemnity. Liability would not be limited to actual fraud, gross negligence, willful default, which is how we've seen pervades all the other contracts in this structure. And indeed, in the investment advisory agreement, clause 6.3, this is at S34, FCM London gives a contractual undertaking to use all reasonable endeavours to procure that its officers and employees shall service the interests of the investment manager as manager of the fund, in good faith discharge its obligations hereunder with reasonable skill and care. And I may have to come back to that in relation to FCM London, because it's also alleged that FCM London had a fiduciary duty to manage its employees. And I say that any suggestion of that is directly contrary to the contractual obligation to use all reasonable endeavours to ensure that its employees act in a certain way.
The fiduciary duty, which is in play in this case, is quite circumscribed, isn't it? It's essentially a duty not to misappropriate money of the fund over which you are entrusted with control. That's the essential complaint, and that sounds a bit like something which is capable of being a fiduciary duty, even if things like no conflict and undivided loyalty more generally have been excluded or waived to some extent.
Well, you might say that if you look at the contractual structure, which has a carve-out for gross negligence, which we saw as something going beyond negligence or fraud or willful default, then I would accept that you could say, well, if the fiduciary duty imposed was only in the cases of, shall not act fraudulently or something, then I would have to accept that it wouldn't then be wholly inconsistent with the particular terms of the structure. But I would still say that it is contrary to the structure as a whole, and certainly contrary to how commercial dealings would normally work, to say that you can have this structure and yet impose fiduciary duties on the people at the end of the chain. It would suggest that all kinds of junior solicitors have particular fiduciary duties owed to people who might be quite a long way up the chain with whom their firms are contracted.
Well, junior solicitors are not usually entrusted with control over large amounts of the client's money. You'd be looking at somebody of partner level, presumably, who might very well be identified with the firm.
I'm simply saying that it would not be normal or consistent with a contractual structure of this type to impose fiduciary duties on somebody at the very end of the line. What I'm not saying, I don't think I can say that it is impossible, and that in the right circumstances, where there are findings and evidence that particular individuals, even at the end of some contractual structure, have, in a manner consistent with that contractual structure, agreed to do, expressly assumed responsibility for certain things and expressly assumed a duty of loyalty, then I would not say there's an absolute legal bar to imposing fiduciary duties in that way, but I do say it's unlikely. And as Lord Justice Leggett said, it's exceptional that they're imposed outside settled categories of relationship, as we saw. And so in my submission, you would be looking for some exceptional findings of fact to show that this really took matters out of the norm and out of the contractual structure that's been put in place.
Well, for example, I think you told us that Mr. Nuseibeh was the man who was entrusted with authority to give instructions to Burgess Salmon about how the proceeds of redemption should be dealt with. Would that fall within the kind of situation you just mentioned?
Well, first of all, it was FCM London that was given instructions to deal with Burgess Salmon. It may be, in fact, that this is in the new documents that my learned friends have handed up, but it's certainly in the particulars of claim, if you just, that's where I know it is. So that's in core bundle.
Well, you were making the point earlier on the question of whether breach of trust by Burgess Salmon was a point which was open. that they were
Yes.
simply following instructions, and that Mr. Nuseibeh was the man who was authorised to give them.
Well, let me just take you to paragraph 34 of the particulars of claim. And at paragraph 34.1, it says, Burgess Hammond retained a letter, was addressed to Zaki Mohammed Global Fixed Income Fund. 34.2, the retainer letter stated, the fund has granted its investment advisor, Floreat Capital Markets Limited, Floreat, permission to give instructions and liaise with us for the purposes of this transaction. Our main contact will be Zaki Mohammed, partner of Floreat. We may also take instructions from and provide advice in this matter to other individuals within Floreat and the fund, including but not limited to the directors of Floreat, so that's Oumar Diallo and Mutaz, and Ben Churchill. So my point is that as the judge repeatedly found, I apologise if I misrepresented the position earlier, it was FCM London that was given authority, albeit there were certain named persons, including but not limited to, from whom Burgess Hammond could take instructions on behalf of FCM London, on behalf of the fund. So my point is that in granting that authority, it's not as if the fund is selecting Mr. Nuseibeh particularly to say he is the person on whom we have confidence to carry this out. What they're doing is they're using the contractual chain and saying, of course, it can act by its directors and, in fact, by these two other people, Mr. Nuseibeh and Mr. Churchill. In relation to the claim that the individual defendants owed a tortious duty of care, which one might think is rather less rigorous than having a fiduciary duty, the judge correctly analysed the position and found that they did not owe a tortious duty of care to the fund, and that's at 390 of the judgment. It starts at paragraph 388, where the fund asked the courts to make a finding that the individual defendants assumed a duty of care to the fund in respect of how they managed the redemption of the financing, and directed the fund's cash flows as a result of the fund's lack of any real oversight. Of course, part of the finding is undercut by the fact that Mutaz was then a director of the fund and clearly did have an understanding of what was happening. And the judge at 389 says, I'm unable to make the finding 20.1 sought, that they assumed a duty of care to the fund. It was FIML, not Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh, that the fund engaged its investment manager. FCM London, not the individual defendants, that FIML in turn engaged as investment advisor. To the extent that the individual defendants controlled information or managed the operation of the facility, they did so as employees of FCM London. It was on FIML and FCM London that the fund relied, including to manage its exposure to loss. He then considers at 391 the fact that they owed to FCM London an implied duty of fidelity, that says, and even that Mr. Diallo owed fiduciary duties as a director, that says those points do not suggest an assumption of responsibility to the fund by them as individuals. I see no principled basis for recognising, as regards employees of FCM London, or imposing on employees of FCM London a duty of care to the fund, or FIML, which did not employ them, in addition to the duties they owed to their employer, and the duties their employer owed to the fund or FIML. To do so would be an unusual outcome or step for the law where the relationships were configured as they are in this case. In my submission, the judge here is clearly finding that no tortious duties were owed. This is entirely consistent with his earlier reasoning that the individual defendants did not owe fiduciary duties either. And indeed, it would be a very surprising situation in my submission where the more onerous fiduciary duties would be owed, but not the less onerous tortious duties. So I've dealt with
You said, I think you took us to Lord Justice Leggett's comments in L9 and Kent earlier about the fiduciary relationship as founded on the acceptance by one party of a role which requires exercising judgment and making discretionary decisions on behalf of another. So looking at it from the point of view of the fiduciary, which is what Lord Justice Leggett was doing, the question of whether somebody is accepting fiduciary obligations.
Do they accept that obligation?
Is the same way of looking at the assumption of the notional assumption of responsibility that you look at in the tort context.
Yes, and this is.
You say there's a parallel there. They're not the same tests. They're not
I'd say
the same purpose, but it's a similar type of parallel type.
Yes,
of
it would
test.
be. My submission would be very surprising for an individual to have assumed responsibility and assumed fiduciary duty to do this, that, and the other. But actually, I'm so far removed from you that I don't assume even a tortious duty.
Yeah,
That's the same point looking from the other end of the telescope.
Yeah.
And my third point is that there is no finding that the individual defendants voluntarily assumed fiduciary duties or indeed tortious duties to the fund. The judge just doesn't identify what they did to put themselves in that position where they would owe an undivided duty of loyalty. My fourth point is there's no, I should say, the first 2 points were perhaps quite extended, so I should remind your lordships what they were. The first is that there's just no direct connection between the fund and the individual defendants. The second was that the imposition of such duties would be inconsistent with the contractual structure. The third is there's no finding they voluntarily assumed fiduciary duties. The fourth is there's no finding that the fund relied on the individual defendants. And in any event, as we also saw in Al-Nahayan and Kent, the mere fact that the fund relied in some way, or a contractual party relies in some way on its counterparty, does not by itself give rise to fiduciary duties. All contractual parties can rely in some sense, or hope to rely in some sense, on their counterparties acting properly, but obviously fiduciary duties do not arise in every case. Fifthly, English law doesn't impose fiduciary duties on wrongdoers merely by reason of the wrongdoing. That's the point that the judge correctly reasons at paragraph 425. And crucially, to return to a theme, I'm afraid, the judge just didn't set out any reasons to support his finding that the individual defendants breached duties to the fund, still less that they actually owed fiduciary duties to the fund, and all his reasoning went the other way. And so, for all those reasons, I would say it's clear that the individual defendants did not owe fiduciary duties to the fund, primarily because that's what the judge found. But in any event, he was right to do so. We've touched upon it, so now is perhaps a good moment. I'll just address it briefly, though I may address it further in closing, which is the respondent's cross-appeal. The respondent cross-appealed, saying that the judge ought to have found that the individual defendants owed tortious duties to the fund, and presumably recognising the force of the point that it seems rather inconsistent to owe fiduciary duties but not tortious duties. I've taken you to the reasoning of the judge why he says they didn't owe tortious duties to the fund. The respondent's single ground of principal complaint is to say that the judge focused too much on the contractual chain, but as we've seen, the existence of a contractual chain is important when considering not only a fiduciary duty, but also whether a duty of care exists. If I could just take your lordships briefly to Riyadh Bank in the Authorities Bundle, tab 11. At paragraph 18, this is on page 337, this is Lord Justice Longmore. Paragraph 18, he briefly discusses Henderson merit as a background and notes that Lord Gough in that case, and this is at H to J, bottom of the page, Lord Gough held the prescribed forms of agency and sub-agency agreements created a chain of mutually exclusive contractual relationships, so that the managing agents owed no contractual obligations to the indirect names. Nevertheless, he held the managing agents did owe a duty of care to those names, pointing out there was no material difference between the contractual duty of care owed to the members' agents by the managing agents on the one hand and the duty that would be owed to the indirect names and tort under Headley-Byrne principles on the other. Only then did he deal with the submission that the indirect names, as parties to the chain of contracts, must be taken to have thereby structured their relationship so as to exclude any duty of care owed directly. Having decided that this submission was wrong, he added, I wish to add, however, so this is Henderson and Merritt, I wish to add, however, that I strongly suspect that the situation which arises in the present case is most unusual, and that in many cases in which a contractual chain comparable to that in the present case is constructed, it may well prove to be inconsistent with an assumption of responsibility which has the effect of, so to speak, short-circuiting the contractual structure so put in place by the parties. It cannot therefore be inferred from the present case that other sub-agents will be held directly liable to the agent's principal in tort. If I could invite you then to look at paragraph 30 of this judgment. Where Lord Justice Longmore continues, the question remains why it is that Lord Gough strongly suspected that the imposition of a duty of care in cases where a contractual chain existed would be most unusual. It's possible he used the phrase because in most cases of a contractual chain, it would simply be unnecessary for a party to bypass the chain. It's perhaps more likely he was simply not considering cases such as the present, where direct and substantial contact has occurred between parties who are subsequently separated by a contractual chain. It is indeed unusual that a judge can make the findings of fact which Mr. Justice Moore-Bick made in the present case. And those findings of fact, it's easiest to, I think, just look at the headnote on the first page of this authority at F, where it says, a company was set up to embody the investment fund, and this was the third claimant, the fund, which entered into, inter alia, an investment advisory agreement with the first claimant, under which the first claimant agreed to act as its general investment advisor. In addition, an employee of the defendant was present at every meeting of the board of directors of the fund and took an active part in discussions in relation to the purchase of leases. So that was a situation where there were unusual findings of fact, where a sub-agent had very direct and substantial contact between the parties, as is put in paragraph 30. And that is the reason why this case distinguished what the Lord Gough's general proposition in Henderson and Merritt. So at paragraph 32, said Mr. Howard relied on building cases for the proposition that where there is a contractual chain, that chain should not be bypassed by a claim in tort. As Lord Gough said in Henderson and Merritt, that is indeed the usual position, but neither of those authorities considered a case where discussions and representations were made directly to the party who, in the event, suffered loss. There cannot be a general proposition that just because a chain exists, no responsibility for advice is ever assumed to a non-contractual party. And that's a point I made earlier. So I don't say it's completely ruled out, but it does make it unlikely. And there's one further point I would draw your attention to at paragraph 136. That's on page 365. And this is in the judgment of Lord Justice Buxton. And he's, the paragraph 136, E to F, he refers to Lord Justice Bingham in Simon General Contracting Co. and Pilkington Glass, and says this: a specific reason given by Lord Justice Bingham for it being implausible that the main contractor relied on the supplier was that the main contractor had not chosen the supplier and had had no dealings with him. He was bound to accept the supplier because that's what his contract with the building owner required him to do. And then by contrast, in a more direct case, where a specialist subcontractor is vetted, selected, nominated by a building owner, it may be possible to conclude that the nominated subcontractor has assumed a direct responsibility to the building owner. In this case, of course, we've seen the provisions that say that the fund did not even appoint or have responsibility for appointing or have a right of veto over the appointment of FCM London as the investment advisor. Still less did it have any appoint or have any right of veto over the employees of FCM London as advisor. So on that basis, the judge can't be criticised for saying that the contractual structure was important. Indeed, the authorities suggest it would be a very unusual situation with unusual facts of showing a direct assumption of responsibility that would give rise to a situation where duties were owed directly. And of course, in this case, the judge found no such duties and indeed took particular care throughout the judgment to make the point that it was to FCM London that certain duties were delegated and not to the individual defendants directly. So my learned friend may have further points on this, in which case I will come back to them. But as a starting point, the judge's decision is entirely in keeping with the authorities. He didn't make any findings that suggested that that normal starting point should be discarded in favour of what is referred to as an extraordinary situation where they would owe such duties. I come now to, so what I have left, just so your lordships know that I hope I am on target, is I have the question of whether the FIML itself owed fiduciary duties to the fund, and also what. And also, I have one or two further comments on the general ground of appeal, but that should be very short. Excuse me. So in relation to FIML, we say the judge was wrong in law on the analysis of the investment management agreement to find that FIML owed fiduciary duties to the fund. I will invite you to take the supplementary bundle, first supplementary bundle. I'm sorry, can I go back a sec? Can I just take you to the judgment first before we look at that? Just to see exactly what the judge says. And that's at 453 to 457. So the fund invited a finding that FIML owed fiduciary duties to the fund in respect of the actions of FCM London and Mr. Churchill, Mr. Diallo and Mr. Nuseibeh, to whom FIML had delegated its duty to manage the redemption of the financing, but in respect of which actions it remained responsible. And then equivalent finding in relation to FCM London. And the judge said, unless the position was successfully changed by the contract between them, an investment manager to an investment fund would readily qualify as a fiduciary owing fiduciary duties to the investment fund. In the present case, clause 13 of the investment management agreement addressing the relationship between the fund and FIML was headed waiver of fiduciary duties. However, clause 1.1b provided that the headings to a clause shall not affect the interpretation or construction of this agreement. The terms of clause 13 itself refer to the fact that FIML is acting as the fund's fiduciary and includes duties arising under any applicable law to which FIML is subject within the duties or obligations FIML owes to the fund. You'll see there are some ellipses between applicable and law and to which, and I'll come back to that. In the circumstances, notwithstanding the heading to clause 13, and giving clause 13 its true interpretation, in my judgment, FIML was the fund's fiduciary and owed the fiduciary duties that arose by law by reason of that relationship. it is not necessary at this point to detail those duties. Fiduciary duties may differ between different forms of fiduciary relationship. And on that basis, leaving aside the reference to it, FIML having delegated its duties to manage the redemption financing to the individuals, which it did not accept, because it was delegated to FCM London, I'm able to make the finding that FIML owed fiduciary duties to the fund. So his reasoning is essentially the position of an investment manager. The starting point is that it would normally owe fiduciary duties. That must be right as a general principle. And so we're looking to see whether those have been, whether the relevant fiduciary duties have been excluded by the contract. But if we now look, if we could take core bundle and look at the particulars of claim as to the fiduciary duties and how it's put. This is on page 232. So paragraph 12 of the particulars, it says, by reason of the following matters, FIML owed fiduciary duties to the fund, and note how this fiduciary duty is put. Owed fiduciary duties to the fund in respect of delegated acts carried out by FCM through the individual defendants in managing the disinvestment of the loan facility, such that, this is still a fiduciary duty, FIML was expected to ensure that FCM, as operated by the individual defendants, showed undivided loyalty to the fund. Those individuals who are in a position to operate FCM do not make unauthorized profits. Those individuals who are in a position to operate FCM were not in a position where their interests conflicted. So, core fiduciary duties. But the duty on FIML is put as an obligation to ensure that its delegate and the delegates, the delegate acting through the individual defendants, acted in the interests of the fund, essentially. So it's a very odd.
Well, it's saying you can't delegate. I mean, you can't by delegation avoid your fiduciary duty. If you're a fiduciary, you can't by delegation of the function avoid your fiduciary duties, and that must presumably mean that you have to ensure that the person to whom you delegate doesn't do something which you yourself wouldn't be entitled to do as a fiduciary.
Well, there is the specific contractual provision saying that FIML will be liable for the acts of its delegates as if they were its own.
Yeah.
That was
Is that
part of the contract. I'm just saying the way in
is
which
that not in essence what that is attempting to say?
that it was but the fiduciary duty is put as a duty to ensure that its sub-agent and its employees act in a particular way, which is a very peculiar species of fiduciary duty, to say the least. So that's how it's put. And for good measure, while we're here, if you could turn the page and see FCM, paragraph 19 of the particulars of claim. It said that FCM owed fiduciary duties to FIML in respect of the delegated acts FCM, through the individual defendants, carried out on FIML's behalf, such that FCM was expected to ensure that it showed undivided loyalty to FIML. Those individuals who are in a position to operate FCM do not make unauthorized profits, and so on. The issue here, of course, is that FIML, the duty that's pleaded, it's not pleaded that FIML has done anything wrong, because, of course, on the claimant's case at trial, Mutaz, sole executive director of FIML, said he didn't know anything about this. And so the pleading is not put on the footing that FIML did something wrong directly and breached the fiduciary duty it might owe in that way. The way it's put is to say FIML acted in breach of fiduciary duty by failing to ensure that the sub-delegate didn't breach some kind of similar duty. It's a peculiar way of putting it. It's not...
How should, I mean, is this right? You'd say if FIML, let's assume FIML owes a fiduciary duty for the purpose of this discussion, but is entitled to delegate, but is required to assume responsibility for the acts of its delegate.
But if it assumes responsibility for the acts of its delegate...
The question is whether the delegate breached a like fiduciary duty, which it must for this purpose be assumed to have accepted.
Yeah, so you'd first have to prove they're trying to short-circuit the system, rather than saying we can show that, you'd expect them to say FCM has breached its duty in some way. The judge, of course, didn't actually find that FCM had owed duties direct to the fund, and we saw that particular clause where it had a contract.
Is it a breach by FCM of its duty which has to be shown, or is it simply that FCM has done something which, if done by FIML, would be a breach of FIML's duty? Because that's what the clause seems to say, that it remains responsible for the acts
Liable for the acts of delegates as if they were its own. So you'd have to identify the...
Well, if I don't have a conflict but delegate to if I'm a fiduciary and don't actually have a conflict but delegate to somebody who does, when they make the decision, is the liability, I must assume responsibility for their acts as if they were my own. I mean, we may need to look at this clause again, but the whole point about a fiduciary is its duty. Let's say a core principle is undivided loyalty. Forget the exclusions for a moment. The beneficiary is entitled to the undivided loyalty in the making of a discretionary decision by a fiduciary. If the delegate is somebody who does have a conflict, why isn't the fiduciary liable for having the acts of the delegate, i.e. the delegate is not given his undivided loyalty to the beneficiary in the making of the discretionary decision? The fiduciary is answerable for that, because it's a breach of fiduciary duty by the delegate.
It's paragraph 3.16 of the investment management agreement is the provision that says...
I mean, normally you can't delegate. The fiduciary doesn't delegate his fiduciary duty. That's the nature of fiduciary duty. Unless he's allowed to, and then you have to look at the...
Well, exactly. But
he's allowed to
delegate.
delegate.
It's my submission that it doesn't say that the fiduciary duty has been delegated. Certain responsibilities have been delegated to an investment advisor. But the way in which clause 3.16 puts it is that it's a contractual duty. It doesn't say that... So let's have a look. It's on page S, bundle S, page 11. It's clause 3.16. Where it says, the second half of this, subject as provided in clause 10, or as may be agreed with the fund from time to time, any delegation or appointment pursuant to this clause 3.16 should be entirely without prejudice to the manager's liabilities, obligations, and responsibilities thereunder. So if you could show a breach of its obligation, a breach by FIML of its obligations. And the manager shall be responsible for the acts and omissions of its delegates as if they were its own. So that is a contractual provision saying that FIML has a contractual liability in respect of the acts of its delegates. But the respondent in this case seems to have taken those words and tried to turn this contractual liability into a fiduciary liability in a way that does not sit with what a fiduciary duty is normally assumed to be, because to breach fiduciary duty by failing to supervise adequately, which is what this in my submission, is extraordinarily unusual. That's why you would normally get best endeavours, reasonable endeavours clauses for those kinds of activities, and not put in terms of it being a fiduciary duty at all. But that's how it's put in the particulars. It's put in this very particular way. And so when we then come to look at what the judge found...
So just to be clear then, are you saying that if the pleading had not characterised the liability of FIML as a fiduciary, breach of a fiduciary duty, but had characterised it as breach of a contractual, sorry, that it was a claim in contract based on responsibility under the contract, that you would have no quibble with the way that it was pleaded?
If it said it have a contractual duty to ensure this, that and the other, that would be a claim against FIML. But of course no claim was brought against FIML because the breach is only relied upon for the purposes of dishonest assistance and knowing receipt. It's trying to cast a contractual provision as a fiduciary provision in order to found the accessory liability claim. And so when returning to what the judge finds, I am conscious of the time, so I must make progress, but returning to what he finds in paragraph 456, the judge says, notwithstanding the waiver of fiduciary duties clause, in my judgment, FIML was the fund's fiduciary and owed the fiduciary duties that arose by law by reason of that relationship. Query whether the fiduciary duty pleaded is not one that arises by law. It seems to be one that arises, if it arises at all, somehow by contract. But the judge goes on to say it is not necessary at this point to detail those duties. And the difficulty is that the judge doesn't detail what the particular duty is when he subsequently goes on to find that it's been breached. Because although my primary submission is that the fiduciary duties are wholly waived, and I'll come on to that just by looking at clause 13 and clause 5, which we've looked at already. But the secondary point is to say, in circumstances where such fiduciary duties as may remain are highly circumscribed by clause 5, and we would say by clause 13 and by clause 5.5, it's important to know what fiduciary duty the judge has found so that we can say whether or not it falls within any of those many contractual exclusions. But what happens here is that the judge expressly says, well, I don't need to detail the duty. And of course, there was no, my lord, earlier you were suggesting that one could sort of assume that the breach of duty was a duty not to misappropriate funds, but that doesn't even work in the case of FIML. There's no claim that FIML has misappropriated funds. So the judge, so looking then to, I think you have my point, which is because the duty is pleaded, it seems to me on the face of it really a contractual duty, not a fiduciary duty. But even if it is some species of fiduciary duty, it's a very odd species, which you would expect the judge to have identified and said, I find that this is a fiduciary duty and here's how it works. And you also need the judge to identify the relevant duty, because only then can you say, does it fall within the various provisions and exceptions. Looking at, so going back to bundle S, S1, the investment management agreement, tab 1. We looked yesterday at clause 5.1, where, in my submission, at the very least, some of the core fiduciary duties are waived. Fund acknowledges and agrees that the manager and its associates may, without reference to the fund, act in circumstances in which they have a material interest or relationship of any description with another party which may involve an actual or potential conflict with the manager's duty to the fund. So that's a pretty wide-ranging acknowledgement and agreement to waive the no conflict rule. And as I said yesterday, to remind your lordships, in my submission it's then replaced by a contractual provision saying if the manager acts in circumstances where it has a material interest or conflict of interest, the manager will take all reasonable steps to ensure the fund is treated fairly. And then the last sentence, neither manager nor its associates shall be liable to account to the fund for any profits made or received in such circumstances. So the no profit rule goes. So if you have it's quite hard to see what's left once you have dispensed with the core obligations of no conflict and the core obligation of no profit. So that's the context in my submission in which we then look at this agreement as a whole. And of course, we've seen at clause 10 there are some quite stringent exemptions for liability and for liability in clause 10.1, and there's an indemnity given in clause 10.3, which shows that the contract as a whole is not an entirely normal commercial contract. It was set up, the defendants say it was set up by Mutaz and his brother, and Mutaz, as we saw, is involved at all stages of the contractual chain, or most of the stages. He was very much in the centre of things. And it's perhaps unsurprising he should have wished to set up a system whereby his liability would be highly circumscribed. If we look then at clause 13, waiver of fiduciary duties, on page 80.
And just to be clear, though, the starting point of all this is the appointment in clause 3.1 as investment manager, with power to take all the decisions and otherwise act as appropriate in relation to the management of the fund. If that stood alone, you would undoubtedly say that gives rise to duties which the law would characterise as fiduciary duties.
Yes, I don't quibble with it.
Doing it the correct way around, according per Lord Millett.
Yes, I don't.
Your starting point, which the judge started with
yes, so
normal terms.
We don't say that we have to look at, with the individual defendants, I'm saying there's no duties is not imposed at all. In this case, I'm saying the natural relationship of an investment manager, given the responsibilities they have, I would accept the starting point is that at least some fiduciary duties would be owed, exactly what you would look at the contract. And so, but I do say what's excluded is excluded by the contract. I'm not saying they don't arise in principle to start with by virtue of the nature of the relationship. So if we look at clause 13, we'll leave the heading on one side for now, although notwithstanding the clause 1.1b, when we were looking at clause 5 yesterday, it suggested, well, if there was an intention to waive all fiduciary duties, why didn't they just say so? My submission is that in terms the parties did say so, albeit there's a provision that says that the way in which they said it can't be taken into account in construing the terms. So looking at clause 13, it says the fund hereby agrees that although the manager will take investment decisions and may act as the fund's agent hereunder. So in the normal course, acting as an agent and taking investment decisions would give rise to fiduciary duties and obligations. So by starting with this clause, subclause although, the purpose of this clause, what follows, is plainly to limit those duties and obligations. Although it's acting in this way, something's going to follow. The natural assumption is they're going to be limited in some way. The second part says the only duties or obligations the manager owes to the fund are those set out in this agreement or arising any under applicable statute, law, or regulation to which it is subject. These are saying the only duties or obligations that arise. These are also, the only is also a limiting word. Again, it goes with the although. It limits, it leads the reader to expect that what follows will limit the duties and obligations that are owed. The definitions of the duties that do apply say those set out in the agreement, uncontroversial, although it's important to be clear whether the duties set out in the agreements are purely contractual or whether they're fiduciary, or arising under any applicable statute, law, or regulation to which it is subject. Now, we saw earlier that when the judge construed this clause, he put ellipses in place of statute and regulation in coming to the conclusion that the fund was subject to fiduciary duties imposed by law, i.e. common law fiduciary duties. I'll come back to this point, but let's just complete the sentence. And that the manager does not owe the fund any other or further duties or obligations, whether arising from the fact that the manager is acting as the fund's fiduciary or otherwise. So the straightforward meaning of this phrase is that no additional duties arise because the manager is acting as the fund's fiduciary. It's also what you might call a limiting provision. Now, on the judge's interpretation, if the manager owes all duties that arise under law, which including common law fiduciary duties, then to say that no further duties arise from the fact that the manager is acting as the fund's fiduciary is OTOs. It doesn't add anything because it's already, on the judge's interpretation, subject to all the usual duties. So this doesn't make a great deal of sense. And the second point in this part in parenthesis is it does, of course, say whether arising from the fact that the manager is acting as the fund's fiduciary or otherwise. It doesn't say that the manager is the fund's fiduciary. In my submission, it's clearly saying the fund is carrying out acts that would normally be seen as fiduciary acts. But notwithstanding that, it doesn't give rise to any further liability. So if we take the judge's interpretation as a whole and say, well, what the clause does is simply to say that the manager is subject to all obligations set out in this agreement or arising under any applicable statute, any applicable common law provision, or any regulation, then we can wield a blue pencil with some liberality, because the fund hereby agrees would be very odd, because it's simply a statement that the manager is bound by the provisions of the contract and all provisions of law. It would hardly need the fund to agree that. The part saying, although the manager will take investment decisions and acts as the fund agent, well, that doesn't take us anywhere. It has no purpose to say, although I'm acting as your agent, I will owe you all the duties of an agent. And then the last clause in brackets is also unnecessary, because if you owe all the duties of the fiduciary, to say that acting as a fiduciary will not give rise to any further duties.
Sorry, wait a minute. If I appoint you my agent, and the document just says I appoint you my agent to go out and get my sandwiches at lunchtime, here's £5. The fact that I don't, sorry, it's one the fact that I don't say, oh, and by the way, that means you can't use the £5 to buy yourself a pint down the pub, you know, for your own benefit. Yes. I've appointed you my agent. The law attaches a whole load of fiduciary responsibilities to that position without them needing to be spelled out.
Yes.
I mean, the opening words of this indicate that the manager is taking investment decisions and acting as agent. And the law will attach a whole host of unwritten fiduciary duties to those two roles. I mean, that's taken as read, and you then got to cut away, if you want to, specifically, any of those particular duties and obligations which are fiduciary in nature. And that's the way it works.
Yes, and
so those words don't, you know, you can't just sort of say, well, those opening words mean nothing. I mean, they are the words that actually, in fact, what they're doing is summarising the earlier provisions in the document, which appoint FIML as an investment manager, give it discretion, give it powers, appoint it as agent, and unwritten, a whole raft of fiduciary duties go with it.
But in my submission, that's not what the clause says, because if that were the case, it would say...
It doesn't need to, because that's what the rest of the agreement does. It's just summarising, that's the context of this clause.
But it says that the fund, if it were simply saying, the import of the judge's construction of this clause is to say that the manager owes all the duties set out in this agreement, or arising under any statute, or common law, or regulation. So on that basis, this on that interpretation, this would not be in any way a limiting clause. It would simply be stating the position. You would expect it to say, the fund, well, first of all, it makes no sense to say the fund hereby agrees, because it's got nothing to do with its agreement in that case. It would simply be a statement that says, as the manager, or since the manager will take investment decisions, it will owe to the fund all the duties set out in this agreement and all duties arising by statute, law, or regulation. But that's not what it says. It says the fund is agreeing something, which suggests that it's not just stating what happens automatically. This is a variation on what would otherwise happen. And then you have the phrase saying, although the manager will take investment decisions, which suggests that despite what would normally happen, something else is going to happen. And similarly, the phrase in parenthesis at the end, although FIML is acting as the fund's fiduciary, this doesn't give rise to any further duties. None of that would be necessary if all this was doing was confirming and saying, you know, you'd expect it to be headed confirmation of fiduciary duties. FIML is acting as the fund's agent and manager, and accordingly will owe all the fiduciary duties and so on at law. So what, in my submission, where the judge goes wrong with this is partly to ignore the surrounding material, but also because he treats law as a freestanding provision to encompass all possible law. Now that, of course, would include both statute and regulation, if law is simply read as a standalone provision. So those elements would also be OTOs. But in my submission, the clause makes much more sense if you read statute, law, and regulation compendiously as one thing. So statute is top of the tree as written act of Parliament. A regulation is a type of statutory instrument at the bottom, although of course there are other statutory instruments as well. And so law is therefore a convenient shorthand for other types of applicable written laws, such as statutory instruments that are not regulations, such as orders or rules, or possibly even when this was drafted, EU directives. And so if you take those three words compendiously, rather than simply treating them as a synonym for law, then you can see that what's being excluded here is the only duties they owe are the ones under the agreement or arising under written statute, things that the parties haven't yet thought of but might have imposed obligations on fund managers. So statute, law, or regulation, in my submission, should be read as a whole and referring to these types of written statute. And the same effect can then be achieved with the bare minimum of violence to the clause if you simply omit the comma after statute. If you read it as statute, law, or regulation, for example, you would say, well, statute law is written acts of Parliament, regulations, types of statutory instruments. And if you read it in that way, the whole clause makes sense. We don't have to battle with the fact that the fund is agreeing that all the usual duties will be imposed. We don't have to battle with the unnecessary verbiage of although the manager will take investment decisions. And we don't have to battle with the unnecessary provision that although the fund is acting as the fund's fiduciary, it won't impose any further obligations, which makes no sense if the full fiduciary obligation has already been imposed. So in my submission, the clause as it stands, even ignoring the heading, if one looks at it and tries to give it a sensible meaning, take into account the other elements of this contract, in particular clause 5, and the unusual way in which this series of contracts is put together. And you can then read it sensibly to say what's being excluded. It follows the title. Fiduciary duties are waived, and the only duties the manager owes are those set out in the agreement or under any statute, law, or regulation, which I would paraphrase as written law. I'm aware of the time. We have a further point in our skeleton argument in relation to clause headings, and there's a lot of authority on that. It is fairly fully set out in my skeleton, so I don't propose to trespass on your patience by taking you through it in detail. I would simply say that the authorities, when you look at them as they are set out, is gives rise to a situation, in summary, I say, where the clause heading in this case says that headings can be taken, sorry, let me find the exact wording. The headings to clauses are for ease of reference only and shall not affect the interpretation or construction of this agreement. In one of the cases, Mr. Justice Lewison, as he was at that time, said that one has to give effect to the parties' intentions. And so when they say this clause, this heading shall not form part of the agreement, one should give effect to that. But I would say equally, where the parties have agreed that the heading is for ease of reference, if the heading is positively misleading, it's not for ease of reference. If you have a heading which is waiver of fiduciary duties, and in fact this is construed as meaning simply imposition of fiduciary duties, then in my submission, that construction would not be giving due weight to the party's intentions in saying it can be used for ease of reference. And so the fact that it can be used for ease of reference is a point that distinguishes it from many of the other cases where it says, you know, headings shall not be part of this, or it simply says headings shall not be used to construe the clause, rather than them having an active purpose agreed by the parties. And so where headings are for ease of reference, as set out in our skeleton, it would be appropriate to take them into account to say, well, if they obviously contradict the clause completely, then you wouldn't do violence to the clause by taking them into account. But where they're consistent with the clause, but may provide some clarification or further information in relation to that clause, then you can take them into account. So I say, my primary submission is the clause will stand by itself, but given that waiver of fiduciary duties is there for ease of reference to tell you what the clause is about, what it does is, if there were any doubt remaining, it simply provides the answer, provides a further bit of information that confirms exactly what this is about, as if there were any doubt as to how it should be construed. And given the time, I'm not going to say anything more about the clause headings. It seems to me the point about construction is the more important point.
Yes.
About how that works. But I also just make the second point, reiterate the second point, I should say, which is, if your lordships were to find that Fimmel did owe some kind of fiduciary duty, it would still be important for the judge to identify what that was. He says you don't need to identify it at this stage, but given the very unusual pleading of the fiduciary duty, to find that there is a relevant breach by Fimmel requires more than simply saying there is some residuary fiduciary duty still owed by Fimmel to the fund, and it has been breached. It would have to be identified so that we could look at it, your lordships could look at it and say, this is the duty that's actually been found, and this particular act was a breach of it. And without that, and in particular, that the fiduciary duty found does not fall within the many exceptions. My final 3 minutes, I intend to just make a brief point about the preparation of the judgment. So this is our general ground 5. This is we've really touched on this several times through the course of my submissions. There's no dispute between myself and my learned friend. It's well established that normally judgment should be given within 3 months of the hearing, and in circumstances where there has been a significant delay, there are a number of cases which both parties cite, saying it can easily be accepted that excessive delay in delivery of a judgment may require careful perusal of the judge's findings of fact and of his reasons for his conclusions in order to ensure the delay has not caused injustice to the losing party. But in this case, the delay is just under 7 months, which is not at the extreme end of these cases, but it's a similar period of delay as in Times newspapers and Singh, for example, which is one of the cases cited. But the point in this case is not just the delay. We wouldn't need the additional evidence if it was just the 7-month delay, because you could see that from the face of the judgment. What we say is when one looks at the evidence, which I hope your lordships have read, we can see that it's not just delay but disruption. So the evidence of Mr. Zavetti says that when no judgment was received after 4 months, inquiries were made at the court on the 12th of November, and on the 19th of November, the judge's clerk replied stating the judge expected to circulate a draft judgment by the end of November. Now, that was only 11 days away, so one could be fairly confident that the judge had started his judgment at that point and wasn't imagining he would do it in 11 days. So it's been started, at least, say, in November. On the 30th of November, end of November, the judge's clerk said the judge was expected to circulate the judgment the following Monday, 6th of December. These are all taken from Mr. Zabetti's witness statement at the back of the supplementary bundle, and the reference is C. That must be a wrong reference, I think. I think it must be S 650 onwards. So on the 30th of November, judgment was promised in 6 days, so one can assume that the judge had made some progress, but hadn't quite finished. On the 8th of November, further inquiries were made, and on the 14th of November, the judge's clerk replied, indicating that judgment might not now be given until the beginning of next term starting on the 11th of January. On Monday, the 31st of January, the judge's clerk emailed the parties that the judgment would be circulated later that week, and the draft was then produced on the 4th. So the point of this evidence, very briefly summarised, is that it's not just a delay, it's the fact that the judge seems to have started his judgment at least in November, and quite possibly before that, and clearly felt himself under pressure because he was promised and then not delivered. It seems to, the suggestion is that it was written over a long period of time and written in chunks. And we've seen that in the way in which the judgment is put together, the way in which it is in places contradictory, and the way in which in places it doesn't seem to take a step back and look at things in the round. And so we've seen the inconsistent approach between the tortious duties and fiduciary duties, proprietary claim dealt with without any reference to authority, the no clear statement of even what unlawful means was used, and the findings without giving reasons. And so in those situations, we don't say this is a freestanding ground why the judgment should be dismissed, but we do say it is a general ground, which means that the court should pay a special care to ensure that the parties have not been, defendants in this case, have not been disadvantaged by scrutinising his findings carefully, essentially not giving him too much the benefit of the doubt in circumstances where judgment is in some ways internally inconsistent. And so that would be a dangerous course to take. My lords, those are my submissions.
Thank you very much. All right, well, we will resume at 2 o'clock.
All rise.